Hey everyone, and welcome back to The Explainer. So today we're unpacking something we all do, probably without even thinking twice about it: making deals. We're going to dive right into the Indian Contract Act of 1872 to demystify the actual anatomy of a legally fair deal. It's kind of like a giant puzzle, and we're putting the pieces together.
Now, you might be wondering, does a signature always mean you actually have a deal? I mean, it seems super simple, right? You sign on the dotted line, you shake hands, and boom, you're locked in. But is signing a piece of paper genuinely enough to legally bind you to a contract? Well, the short and maybe surprising answer here is absolutely not. A mere agreement just isn't enough. The law requires something way deeper than that.
Okay, let's dive into this. The absolute baseline for any deal comes down to a legal concept called consensus ad idem. Basically, that translates to a meeting of minds. Under Section 13 of the Act, for a contract to even exist in the first place, both parties literally have to understand and agree to the exact same terms in the exact same sense. Because think about it, if your minds aren't meeting, neither are your legal obligations. To brilliantly illustrate what happens when two minds just flat out miss each other, we have to look at the fascinating old case of Raffles v. Whitchelhouse. So, picture this. Two parties agreed to a deal for cargo coming in on a ship named Peerless. The catch? There were actually two entirely different ships named Peerless, sailing at completely different times. One guy meant the first ship, the other guy meant the second. No way, right? The court stepped in and said, look, there's no consensus ad idem here, no meeting of the minds. And because of that fundamental misunderstanding, there was zero contract. But as you know, free consent is pretty fragile. We're going to be looking at four specific villains that destroy it: coercion, undue influence, misrepresentation, and fraud. And then we'll wrap up with the resolution. Let's start with Section 1, coercion, which is essentially the threat of force. So coercion destroys consent through physical force or unlawful criminal pressure. The Act defines this as committing, or even just threatening to commit, any act forbidden by the Indian Penal Code. We're talking threats of physical injury or worse. But interestingly enough, it also includes the unlawful detention of property. And let's be real here, holding someone's property hostage isn't exactly a tough negotiation tactic, it's literally just a crime. And the ultimate goal behind all of this pressure? The intention to force someone to enter into the agreement. Which brings us to a really dramatic real-world case. Chikkam Amaraju v. Chikkam Sashama. In this one, a man actually threatened to commit suicide if his wife and son didn't execute a property release deed. The court ruled that yes, even a threat of violence against oneself totally amounts to coercion under Section 15. Why? Because it creates this overwhelming, unlawful pressure that absolutely destroys any sense of free consent. Moving right along to Section 2, undue influence, or abusing power. Now, unlike coercion, undue influence doesn't rely on physical force at all. Instead, it's all about relational dominance. This happens when one party is in a dominating position, usually in a relationship built on deep fiduciary trust, like a doctor and a patient or a lawyer and a client. They leverage that position to obtain an unfair advantage, which completely strips away the weaker party's independent judgment. So sure, they technically agreed on paper, but their free will was essentially hijacked by the very person they trusted. Interestingly, the sources point out a unique cultural and legal detail here. The law provides special protection to Pardanasheen women living in seclusion, because they might lack access to independent advice and might not fully grasp the whole shebang of the transaction. The law legally presumes inequality right out of the gate. It actually flips the script. It forces the dominant party to prove that they gave a full explanation, made sure the woman had independent advice, and that her consent was in fact genuinely free. Up next is Section 3, misrepresentation, also known as the innocent mistake. Misrepresentation is really all about that innocent mistake. This is when someone makes a false representation of a material fact that induces the contract, but, and this is absolutely crucial, there is zero malice here. The person making the statement honestly truly believes they're telling the truth, or maybe they're just being a bit careless. But because the other party agreed based on that bad information, their consent wasn't actually free. And this brilliantly illustrates the real danger of simply sharing what you think is true. In the case of Smith v. Land and House Property Corporation, the court showed that just carelessly throwing out a false opinion can totally trap someone into a bad deal. It can legally amount to misrepresentation if the actual hard facts don't justify that opinion in the first place. Let's look at Section 4, fraud. The intentional deception. All right, this is our final and definitely most malicious villain.
Just like with misrepresentation, someone is giving false information. But the massive game changer here is that the person actually knows it's false. Their direct, calculated intention is to deceive you. The law is incredibly strict on this. Even just making a promise to do something when you have absolutely no intention of ever keeping that promise, yeah, that crosses the line straight into outright fraud.
The landmark case of Dairy v. Peak really anchored how strictly the law views this kind of thing. It ruled that deceit has to be a highly calculated, intentional act designed to manipulate the other party specifically to obtain their consent. Make no mistake, the law strongly condemns this level of deliberate manipulation.
But okay, here's a super surprising fact when it comes to fraud. Generally speaking, mere silence is not fraud. Keeping your mouth shut during a deal is usually completely legal. The big exception, of course, is if the circumstances explicitly demand transparency, meaning you have a specific legal duty to speak up, or if your silence is basically the equivalent of speech. But otherwise, it's largely up to the buyer to ask the right questions.
Now, what's really interesting about this slide is how it perfectly frames the ultimate face-off between these last two villains. When you pit fraud against misrepresentation, it really all comes down to intent and damages. With fraud, because of that malicious, dishonest intent, a victim can actually claim financial damages. But with the innocent mistake of misrepresentation, you generally can't claim damages, simply because that malicious intent wasn't there.
Finally, Section 5, the resolution, protecting the vulnerable.
So what does this all mean? How does the law actually protect people who get trapped by these four villains? Well, the answer lies in the voidable contract. This is the ultimate legal remedy. If your consent was destroyed by coercion, undue influence, fraud, or misrepresentation, the contract doesn't just automatically get thrown in the trash. Instead, the law empowers you, the victim. It gives the aggrieved party total control to decide. You have the option to rescind the contract, meaning you cancel it, rip it up, and walk away. Or, hey, if it actually turns out to be a solid deal for you despite the bad behavior, you can choose to affirm it and keep it in place. You hold all the power. Which brings us to the end of our explainer and leaves us with one incredibly important thought. We sign terms and conditions, contracts, and agreements practically every day. But based on everything we've unpacked today about the meeting of minds, coercion, undue influence, misrepresentation, and fraud, I really want you to ask yourself, next time you agree to a deal, is your consent truly free? Just keep that in the back of your mind the next time you're handed a pen. Thanks so much for learning with me today, and I'll catch you in the next explainer.